Check. Check. Good afternoon. My name is Jorge Castillo, and it's my privilege and honor, on behalf of CISA Centro de Investigaciones Zarata Abogados, to welcome you to presence Mexico's national rounds for the 25th Annual Stetson International Environmental Moot Court Competition. We're live streaming on YouTube as I speak. Thank you for joining us. The participating teams represent two law schools with great tradition, and the purpose of the moot was to assign an environmental case involving an international law conflict that our participants had to analyze to come up with creative solutions. This competition demanded the preparation of a previously delivered written memorial by the participant teams, as well as the oral defense of their chosen positions. Therefore, the purpose of this event is the final part of the competition, which corresponds to the Mexican national oral rounds. For this, I remind the participant teams that the winner of the competition will automatically have the opportunity to represent our country in the Stetson's international rounds. But this could not be possible without the help and support of our moot court judges. On this occasion, we're honored to announce as our oral rounds judge a specialist in environmental law, Mr. Rolando Ibarra Rodriguez. In regard to the analysis of the written memorial, we are equally honored to have counted with the participation of a specialist in advocacy and environmental law, Mr. Atul Alexander. Finally, we appreciate the participation as bailiff of Mr. Luis Gerardo Fernandez Martinez, who will guarantee that the present event complies with the rules given for the competition. To officially start this competition, I will introduce the participant teams and their corresponding members. Team number 007, representing the applicant, is composed of the following members: Ana Karen Delgadillo Muñoz, Carla Giselle Bonfil Solís, and Miguel Torres Salazar. Team number 002, for the respondent, composed of the members Ricardo David Hernández Saldaña, María Fernanda Guerra Lorenzo, and Ricardo Garza Acebo. In order to comply with the rules given for the competition, I hereby request the members of both teams to prepare their microphones and their video cameras. Once again, we will welcome you all to our present competition. Good luck.
Thank you, Mr. Jorge. Good afternoon to everybody. My name is Luis Gerardo Fernandez, and I will be acting as bailiff in the following trial. I would like to clarify the rules regarding the next trial. First of all, the oral round will be limited to 60 minutes, in which each team will have 30 minutes to argue. Second, the team representing the applicant in the round may reserve up to 5 minutes of their time for rebuttal by informing me before the beginning of this trial how much rebuttal time will reserve and the time breakdown for each team member. Requesting rebuttal time from the presiding judge in the beginning of the applicant's argument. Only one team member may argue on rebuttal, either participating any given rebuttal. The team member arguing the rebuttal doesn't need to be designated in advance on the argument. The applicant may not otherwise reallocate time once the round begins. Sur-rebuttal by the respondent will not be allowed. Nothing in this rule requires a 50-50 split of time between co-counsels. However, any reserved time not used by any oralist will not be reallocated to another oralist. I will keep the official time for each team member and provide time cards with these numbers. During the oral arguments, laptops or other electronic similar devices are not permitted at council table. Neither visual aids nor other similar devices may not use during oral arguments. No documents should be handed to the judges. Further, all team members, coaches, advisors, and observers must refrain from identifying a team school at any time and in any matter, including, but not limited to, wearing any identifying items such as school clothing, patches, or pins, or any carrying identifying material. Finally, all team members and individuals affiliated with a team are prohibited from speaking with the judges before a round. Having specified the rules of this trial, I wish you all good luck. The court is now open and in session. The Honorable Judge Rolando Ibarra Rodriguez presiding. All persons having business before the court come to order. This is the case of Republic of Rumbetti versus Federal States of Alducra. Please, Judge.
Thank you very much, Bailiff. I welcome the parties to this court. And if you please announce the party who will be presenting its case first.
Good afternoon, Your Honor. I'm having trouble with the image, so it's okay?
I would actually prefer if you could delete the image and just show the background, stop from showing that background so I can, so that the court can see you more clearly. Thanks.
You're welcome. Well, first of all, I want to ask for 2 minutes for the rebuttal, okay?
Yes.
Good afternoon, Your Honor. First of all, we are here in representation of the Republic of the Federal States of Alducra. First of all, in conformity with Article 40, Paragraph 1 of the Statute of the International Court of Justice, the Federal States of Alducra and the Republic of Rumbetti have submitted by special agreement their differences concerning questions containing Annex A relating to the protection of patents and international trade measures, and transmitted a copy thereof of the Register of Court on 24th July 2020. First of all, Alducra and Rumbetti are neighbors at Arquiterpo. They develop agave tapajum, the royal noctule, and the long-nosed bat provide them the benefits of pollution, seed dispersal, and insect control in agave farms. Rumbetti's government started the construction of a wind farm to mitigate the climate change. The first phase was constructed on roosting areas, migration route, and commuting routes for the royal noctule bat and the long-nosed bat. A regional bat conservation found 237 dead royal noctules near the wind turbine during 2017 and 356 in 2018. Rumbetti's government refused to implement mitigation measures for the operation of the wind turbines and legislate bat-safe agave farming practices in their territory. Therefore, Alducra established requirements of import and sale of tapajum that imposed a 20% tax in all of tapajum products, and also established that all imported or sold tapajum will be labeled with a specific label indicating if tapajum was bat safe or not bat safe. Our arguments are these. Rumberi violated its obligation to conserve migratory species, particularly the vulnerable royal noctule and archeterpan long-nosed bat under the CBD, the CMS, and Eurobats. A state may be responsible for an internationally wrongful act not only by acting directly to contrary international law or through the attributed actions of private entities under the jurisdiction of the state, but also by failing to act in conformity with its obligations. Rumberi, being a state of the range like Alducra, should have participated in cooperation with it to conclude agreements for the conservation of endangered species. A range state is a state that exercises jurisdiction over any part of the range of the migratory species. Also, Rumberi took no action to prevent migratory species from becoming endangered according to Resolution 7.25 of the CMS. Rumberi also did not perform any assessment after the construction, being merely satisfied with the EIA conducted previous to the construction. Therefore, it should have implemented the strategic environment assignment procedure respectively, as well as monitoring the projects for the management of renewable energy projects, mitigating the impact of bats, which collide with the wind turbines and barotrauma, in order to avoid protected areas in the broadest sense with a specific plan to avoid damage to migratory species. Rumberi should have ensured mitigation measures during the project process, maintained them after completion, as well as have maintained the monitoring. An example of mitigation measures Rumberi may implement are the blade feathering, the higher turbine cut in wind speed, or the shutdown of the turbines, since they are proven to be the only mitigations that effectively reduce the bat mortality according to the Eurobats. Rumberi cannot claim that the CBD has a limited language and that the Rio Declaration is not binding, because according to Vienna Convention states that the provisions of the treaties must be read in the context of their object and purpose, and because when signing treaties, they were submitted to the principle by pacta sunt servanda, which means that dictates every convention must be executed in good faith. An example of a case is a whaling in Antarctica, which was Australia versus Japan. The court stated that the court forced countries before to revoke their implementations that contravene treaties to which they are part. Another argument is that Rumberi directly violated customary international law by failing to comply with its obligations by not establishing the measurements needed to protect environmental damages they have created, and by causing specific damage to Alducra, because since bats can no longer migrate to Alducra to pollinate the agave farms, farmers can't any longer achieve their production normal rates. Consequently, Rumberi has incurred international responsibility and is liable to cease its activities and adequately compensate Alducra based on the case of Costa Rica versus Nicaragua, in which the court decided that damage to the environment caused by one country to another that prevents production must be compensated according to international law. Also, according to the case of pulp mills on the river Uruguay, both countries could have proper use of their equity parts of the territory, but they needed to protect each other's environment. In conclusion, as determined in the case United States versus Iran, when a state fails to comply with international law that causes damage generates liability. Rebuttal directly violated the precautionary principle set forth in the CVD by allowing acts with its jurisdiction that, based on facts, demonstrate the danger to biological diversity and therefore harm to other countries. A case like this was the trail smelter arbitration, in which the responsibility of the countries to avoid acts within its jurisdiction caused damage to another countries. Rumbetti caused transboundary harm by avoiding implementing mitigation measures and affecting the migration route of the bats, which are responsible for the pollution of the agave plants and the agave farms in Alducra, affecting directly the environment of Alducra. The responsibility of states to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states when exercising their sovereign right to use their natural resources pursuant to their own environmental policies. The breach of the obligations of Rumbetti is not justified or exempted by international law. The limit to sovereignty right of states to use their natural resources is limited by the damage they may cause to other states. Rumbetti did not act in accordance with the precautionary principle because the Paris Agreement prohibits damaging the environment in the process of developing renewable energy. Therefore, wind farm turbines do cause harm, and it does need to be substantial it does not need to be substantial to be actionable, but to be measurable by objective standards and facts. Also, it causes damage because they destroy and obstruct the migration route of the species, causing damage to the species, and therefore there is enough reason to be actionable. So now my partner is going to continue with the arguments.
So right now we are going to see what are our main arguments, that they consist in the following. First, that the agreement is the first agreement, that is the ARTA, establishes that the agreement cannot be used to damage the protection of humans, animals, or any other planet life health. Meanwhile, the Article 4 of the Europact establishes that the obligation of the parties to impose legislative and administrative measures for the protection and effectiveness of this agreement. The provisions of the provisions of this treaty do not prevent the parties from establishing more strict measures for the conservation of the population of the bats. The prevention measures are permitted and imposed by the CVD Convention, which both parties sign. Prevention measures are allowed and imposed by the CVD signed by the two parties. The Article 10 of the CVD establishes first that the state needs to take into consideration the use of sustainable resources, but it also states that each contracting party shall, as far as possible and as appropriate, integrate consideration of the conservation of sustainable use of biological resources into national decision-making. Meanwhile, the Article 8 of the CVD establishes that the parties shall, as far as possible and appropriate, develop the legislation and regulations for the protection of the species and populations. The royal noctule and the long-nosed bat are endemic species protected by the lists of treaties that they were signed by both parties. These treaties are the UCN Red List, the CITES Appendix Number 2, the CMS Appendix Number 2, and the Eurobats. The measures consisting of tagging and 20% taxes were taken to remedy and prevent further transboundary harm. Yes, because Alducara has acted in promotion to the Precautionary Principle, which is a customary international law principle that requires that countries need to avoid transboundary pollution and prevent pollution at the source, minimize environmental damage, and also they need to reduce the risk of harm to other states. In this case, Rumbetti is causing Alducara the damage by killing the bats with the wind farm. We also acted in accordance with the establishment in the Principle 15 of Rio Declaration, which mentions that where there are threats or irreversible damages, the lack of certainty does not need to be a reason for the cost-effective measures to the prevention of environmental degradation or the irreversible damages. We acted in accordance with the principle also of due diligence, that take necessary and appropriate measures. States are responsible if they did not act accordingly. It is an obligation of the states to do their best effort for this not to happen. It was acted in accordance with defense of due diligence. The measures were implemented to defend the ecological guarantee that harm will prevent it, but an obligation for a state to exert its best efforts to minimize the risk. The precedent of Gavikovo Najimaro's case established that the court considers, first of all, that the state of necessity is a ground recognized by customary international law, or precluding the wrongfulness of an act not in conformity with an international obligation. It observes, moreover, that such a ground for precluding wrongfulness can only be accepted on an exceptional basis. It also held that safeguarding ecological balance has become to be considered an essential interest for all states. Alducara was forced to invoke the defense of necessity and take measures to prevent further damages to its essential ecological interests, considering the construction of the wind farm had already killed several bats. So, according to Rumbetti's violating actions and omissions to international law, it causes to a vulnerable species. Therefore, Rumbetti has incurred in international responsibility. We request the court to ask for Rumbetti to cease its activities and adequately compensate the damage. That will be all, Your Honor. The rebuttal. By rebuttal, the state of Rumbetti, when building the wind farms, alleges that they were installed to combat the effects of climate change, but they established that Alducara violates international treaties according to the measures imposed on the Tapajos. If Rumbetti wanted to change and help climate change, they will not mind complying with the measures imposed with Alducara, which are based on international treaties and agreements signed by both parties. Therefore,
you have 10 minutes.
Thank you. These measures were taken by Alducara because Rumbetti refused to comply and establish measures in relation to its wind farm. Alducara established these measures for the prevention, reduction of the deaths of the bats. That would be all to the court.
Thank you very much. Bailiff, if you may instruct the next party for them to present the arguments, please.
Please proceed, members of Republic of Rebuttal, please. Members of Republic of Rebuttal, are you ready to begin?
Yes. Well, good afternoon, Honorable Judge, and to all the present. We are Team 2, made up Ricardo David Hernández Saldaña, María Fernanda Guerra Lorenzo, and Ricardo Garza Cebo. Today, the responsible to what was say the applicant we heard and sorry the legal security and benefits of the Republic and the Rupeti. The federal state of Alucra violates Article 1, 7, 8, and 10 of the Archipelago Regional Trade Agreement ARTA. Witness the ARTA Commercial Treaty the day of the celebration is the thus begin this year 2000, having seen say three the federal state of Alucra, the Republic of Rupert, and the other nation state of the archipelago having admission when signing the treaty in which the favoring of customers and charge of the kind of taxes on imports or exports stand out with Alucra violate that the time of electionary the state within its national police which impose do not have a protection protocol for bats. The state is carried out on the evidence meticulous manner by Alucra, this the order to impose its own environmental policy in this nation, considering the Rupert is a developed nation in which its coming depends on the importance of tapagium, and although this pressure is a return that Alucra the only thing that seeks to article is to impose its own measure if is all imposed on violate privilege stabilization agreement on nation more than Alucra in the future. What other agreement will this impose? The federal states of Alucra bears the respect that in the Charter of the United Nations establishes ways and agree between the members that for an equal law and for the free determination of peoples. The federal states of Alucra not only violate the provision established in Article 27 of the Vienna Convention of the Law of Treaties and 55 in the relation to Article 56 of the Charter of the United Nations, seen in internal law of a nation and the observance of the international treaties of which the country parties to dispute are part may not invoke and part the improvisation of the internal law has as justification for the branch of 3, the foregoing serves to estrange the facts and reins to previous items on event, where the fact that the federal state of Alucra are trying to impose a national tax regulation on a product their nation to clearly invisible. As well, the police it's a energy matters to a government property. This begin on direct use towards Alucra happening in the government of its neighborhood country will submit to this commercial and environment regime regardless of whether these consumers the property. In addition, the wind farm project that property begin at the public economy seeks to implement to company with the United Nations framework compensation agreement change in the conventional but countries parties to dispute begin members of a convention having said the above is to know that Alucra has a developed economy based on what is explained by the well-known facts. They begin the case. I will be expect that by forming part of the city convention, it will seek continually and completely to carry out or support police projects, technology, and stress or process that help to reduce both your country and neighboring countries. It which by advance the gases that generate the greenhouse effect the second and world environment styling or continuing on renewable energies and will help this purpose. Within the foregoing, I can be corroborated that Alucra acts in a preliminary and abuse and manner with respect to the self-determination of country and say preserved in the United Nations Charter, but country begin members of say universal treaty when trying to impose in a oppressive way their international policy in their property government. That's all.
Will Rembetti be presenting a rebuttal?
I think they used that time.
Okay.
I'm sorry, you
Bailiff, there's supposed it appears that they're having some problems.
I think it's Ricardo, member of the team of Rembetti, Your Honor.
Okay.
They have remaining like 20 minutes. So is there any member of team Rumbetti who wants to participate, or besides Ricardo?
No, George. Thank you.
Okay.
Bailiff, could you please just tell the parties what the next stage consists on?
Of course, Your Honor. Well, all pay attention, please. The court will deliberate now. So the participants of this trial, please proceed to shut down your cameras and wait to be called back in. Thank you very much.
And now we'll have a 15-minute break for deliberation.
Okay.
And now, the judges will address the parts with the result of their deliberation. First, Judge Alexander on the memorial.
Yeah. So, firstly, I would like to thank Mr. George for the invitation, for inviting me to judge the memorials. I would also like to thank the fellow judge, Mr. Rolando Ibarra. So, before uh, before moving, yeah. So yeah, yeah. So before proceeding into announcing the memorial results of the memorial, I would like to give a kind of overview on the arguments made by both the sides, the respondent side and the appellant side. So, firstly, I would like to start with making some general observations. So, in such a moot court, wherein you talk about Stetson moot, it is pivotal for you to maintain a balance between treaties, general principles of law, and customary international law. And in both the memorials, I was able to find a mix of all these aspects. So, for instance, when it comes to treaties, one of the teams argued on Vienna Convention on Law of Treaties, Article 31. So, essentially, international law as a body lacks what we call as an international spokesperson. So, treaties are the main repositories for interpreting international law. So, it is important that you rely on a VCLT, and I could see that one particular team has relied on that. That is really good. The second aspect about Stetson Moot is it's all about soft laws. You're relying on multiple resolutions which are not hard law conventions or a treaty. So it is important and pivotal for you to establish the fact that it's something that is binding in a court like ICJ, which goes by hard law rather than soft laws. So the second point that I would like to highlight is customary law has to be proven through the reliance on the general resolution. In this particular case, the Eurobat resolutions and the CMS resolutions, right? So I think the appellant side, team number 007 was able to do that with ease and with conviction, right? So the other part that I would like to highlight is regarding the fragmentation of the subject. International law itself is fragmented, and it is important for you to note that you need to reconcile, and you need to be in a position to interpret the subject in a proper manner. So this is where the fragmentation of international law comes into play, and you need to reconcile and apply what we call a systemic interpretation or harmonious interpretation while interpreting international environmental law treaties. And I think the teams that I've seen have you have somewhat managed to do that. And final point which I like to make before concluding and announcing the memo result is with regard to the principles. So in this particular moot court competition, there are a lot of principles that you might have relied on, like precautionary principle, like principle of due diligence, like the principle of sustainable development. So whenever you whenever you try to prove these principles before International Court of Justice, make sure that you prove it through convention as well as the opinion of the judges from the ICJ. So, for instance, the cases like Gapchiko, Nagimoros, there were opinions given by judges like Trinidad, who talk about precautionary principles, who talk about principles of due diligence. So, it is important for you to rely on the separate opinion of the judges, wherein you will get enough of jurisprudence. And that is something that I found missing in both the teams. You relied on cases like Yapchikovo, legality to the threat or use of nuclear weapons, the pulp mills case, the nuclear test case, but none of you relied on the separate and the dissenting opinions of the judges to prove, to augment the position with regard to some of the principles that I have highlighted, right? So with this brief views which I had and I wanted to convey, I would like to say the appellate, if I'm right, the team code is 007. I think they have done their memorials really good. There's always a room for improvement. They can improve more for the world rounds. But I found their memorial to be better in comparison to their respondent 002. But having said this, there is still room for improvement. Hopefully, when you take part in the world rounds, you could mitigate all those minor issues which I have addressed through this my brief views on the overall scheme of things. So I'd like to thank the Stetson Mexico organizers for putting up a kind of wonderful show. Yeah, it's midnight here, but I really enjoyed the arguments, and I'm happy to be part of this event. Thank you so much, George, for the invitation.
Thank you, Judge Alexander.
Yeah.
Now, Judge Ibarra on the oral participation.
Thank you very much. I would also like to begin by thanking the Stetson's organizers in Mexico. I give my regards to my fellow judge, Mr. Atul Alexander. After hearing my fellow judges' arguments and explanation and feedback to both of the parties on how to make a better presentation of its case, of their cases to the court, it's hard for me to add something else. However, I will make some just two brief comments regarding the party representing the country of Al-Dukra. I considered that the oral presentation regarding the impact that the Rumberi wind farm was causing on its country was well presented by the attorney Ana Karen Delgadillo. I found that the arguments regarding the tax imposed to Rumberi, it could have been more complete, more comprehensive. And Judge Alexander also made this comment about having a more comprehensive approach. I think that the arguments that were presented to us, at least in the oral part, did not present this comprehensive approach. Rather, they just argumented that they were being done as almost as a retaliatory measure. It was not used this term, but certainly the arguments seem to point out that it was because of that. And that would not have necessarily been the best approach. Those arguments could have been easily used by the attorneys representing Rumberi, but unfortunately, the presentation was not made very clear. I commend Mrs. Fernanda Guerra for her effort on her presentation, but I think that in this case, the arguments made by Al-Dukra were well more presented. Having said that, I turn now to the bailiff and Mr. Jorge Castillo for the next part of of the program.
Thanks, Judge Ibarra. And now we'll go on with the award ceremony. It's been a real pleasure to appreciate the hard work of each of the participant teams during these national oral rounds. I'm sure that your corresponding faculties were well represented, and so they should appreciate the effort of their students. Now, after the termination of the oral rounds, it's time to announce the following awards of the competition. The best oralist of the regional rounds is an individual award given by the oral rounds judge for an outstanding oral exposition and a remarkable defense. Now, this award corresponds to Ana Karen Delgadillo Muñoz. The best written memorial. The best written memorial award is given by the memorial judge for a notable comprehension of the case and a solid argumentation. Now, this award goes to team number 7. Finally, it's time to announce the winner of the Mexican National Oral Rounds. Prior to this, it's important to mention that the results were determined considering both of the scores of the written memorials and the oral expositions. But before announcing the final award, on behalf of the CISA Centro de Investigaciones Zárate Abogados, I hereby grant the following recognitions to Mr. Rolando Ibarra Rodriguez, Mr. Atul Alexander, and Mr. Luis Gerardo Fernandez Martinez, who made today's event possible. Finally, the winner and champion of the Mexico's National Oral Rounds corresponds to team number 007.
Thank you.
Thank you.
Congratulations.
Congrats.
Congratulations to all team members and the coaches who helped them. Once again, it's been a real pleasure being a part of this event, and on behalf of CISA, we thank you for joining us. Good day.
Bye.
Thank you.
Have a good one.
Felicidades.